for now is, rather than just moving part 2 and then moving into part 2, I want to ask Matthew then to explain why these items have been moved into part 2 and how they qualify there. So we all have a good understanding. Experienced council will know why we're doing these sort of things, but if any general public are watching, may not understand everything what we're doing. So I think it's a good idea to have our legal officer to explain why we have to move some items into part 2 and then give a rationale and reasoning behind that.
Thank you, Chair. The leaders asked me, given that it's a new cabinet, some new cabinet members, to go through the process that you're currently considering. As you'll be aware, as with all committees, including the cabinet, there are some access to information rules, which mean that no less than 5 working days before the meeting, the agenda and the reports will be sent to you, but also will be made available to the press and to the public. When those reports are being produced, and sometimes in consultation with the councillors as well, officers will review the contents of the report and see if it's likely that they may at any point, with regard to the contents, require a decision to exclude the public and the press for the consideration of some part of that information. So what they will do then is the officers will then make a decision as to withhold that information from the public and from the publication until it gets to this meeting, when you'll consider whether or not it's confidential or not. And that's why you have, for those who prefer paper, you have the pink paper, which the public will not receive. Obviously, if you look on the website, those Part 2 reports will not be, as we call them, Part 2 reports will not be there. So when we get to the meeting now, this moves from officers being precautionary and wondering whether or not you are going to consider this in public or not with all the information. It moves over to you. This is your decision, okay? And what you are looking to do is to consider the information that you've been through in the reports and decide whether or not there is certain information within it that needs to be considered to the exclusion of the press and the public. Now, the law says there are certain categories which need to be considered, and those are in the report as well. They're in the agenda and in the header to the actual cabinet reports. And it's important just to go through those. The whole list of them is contained within the Constitution. Part 4, Section E has a whole section on access to information rules. And what you'll see from the agenda this time is with regard to the 2 reports, and of course my computer's just locked itself, with regard to the 2 reports you've just been considering in terms of solar farm, in terms of the sale of some land through Y Regen, some of that information is covered in Category 3 and Category 5. Now, Category 3 means that when officers have assessed it, they've seen there's information relating to the financial or business affairs of an individual, and that can include the council in that as well. Category 5 is that they've seen the reports contain information in respect to which a claim to legal professional privilege could be maintained in legal proceedings. So having identified what those 2 categories are, it's then put for you to make a consideration as to whether or not you want to keep those things confidential. The way in which you do that, if you decide that it's appropriate to do that, you would formally move, second and vote on moving, as we call it, into Part 2, and therefore for the press and the public to be excluded. Then you will make the remainder of your decision, having considered some of the Part 1 information as well, and obviously you'll move on from there once the decision is made. There's a couple of points I want to mention at the end as well. Just because it's in Part 2, it still means it's capable of calling. And just because you decide, if you decide today it's going to be taken into Part 2 and the press and public excluded, it doesn't mean it's confidential forever. And if at some point in the future you decide the information is no longer commercially sensitive, or there's no longer needs to have legal privilege attached to it, then you can decide that it can be released to the public at that time in the future. So now the consideration is up to you as to what you want to do. And if there are any questions, happy to take them, or any further queries outside of the meeting. Thank you, Chair.
Right, thank you, members. I think the recommendation on the paper is obviously it's exempt, and it's a Part 2 item because it's of categories 3 and 5 of the Local Government Act 1972, Schedule 12A. So that's the thought. Now there's some sensitive commercial information in the paper. Would you like to proceed, or it's been moved and seconded to move into Part 2 and not disclose the commercial sensitive information? We'll I'll take that to a vote, moved and seconded, so we decide to part 2. Is it not unanimously? Is one, yeah? It's unanimous, yeah, that's fine.